Thank you. Finally, I feel compelled to make an observation about the risks of participating in this deposition. The most powerful person in the world has said that Mr. Smith should be in jail because of his work as special counsel. Not because Jack did anything wrong, but because he had the audacity to follow the facts and the law and apply them to that powerful person. And through its actions, this Justice Department has demonstrated its eagerness to follow President Trump's orders, despite the facts and the law. Yesterday, the President's Chief of Staff is reported to have confirmed in interviews that the President is indeed pursuing criminal prosecutions against his perceived adversaries as part of a retribution campaign. In the face of those threats, Mr. Smith appears today undaunted, comforted by the knowledge that not only did he do nothing wrong, he conducted his work as special counsel with integrity, impartiality, and an uncompromising commitment to the rule of law. If the committee will allow, Mr. Smith has some remarks that he would like to share.
Thank you for the opportunity to discuss my work as special counsel. I was taught as a young prosecutor to follow the facts and the law, and to do so without fear or favor, to do the right thing the right way for the right reasons. For nearly 3 decades, I've been a career prosecutor. I've served during both Republican and Democratic administrations, and I've been guided by those principles in every role I've held. I continued to honor those principles when I was appointed to serve as special counsel in November of 2022. The decision to bring charges against President Trump was mine, but the basis for those charges rests entirely with President Trump and his actions, as alleged in the indictments returned by grand juries in 2 different districts. Our investigation developed proof beyond a reasonable doubt that President Trump engaged in a criminal scheme to overturn the results of the 2020 election and to prevent the lawful transfer of power. Our investigation also developed powerful evidence that showed that President Trump willfully retained highly classified documents after he left office in January of 2021, storing them at his social club, including in a ballroom and a bathroom. He then repeatedly tried to obstruct justice to conceal his continued retention of those documents. I remain grateful for the counsel, judgment, and advice of my team as I executed my responsibilities. I am both saddened and angered that President Trump has sought revenge against career prosecutors, FBI agents, and support staff simply for doing their jobs and for having worked on those cases. These dedicated public servants are the best of us, and they have been wrongly vilified and improperly dismissed from their jobs. I made my decisions in the investigation without regard to President Trump's political association, activities, beliefs, or candidacy in the 2024 presidential election. We took our actions based on the facts and the law, the very lessons I learned early in my career as a prosecutor. We followed Justice Department policies and observed legal requirements. The timing and speed of our work reflects the strength of the evidence and our confidence that we would have secured convictions at trial. If asked whether to prosecute a former president based on the same facts today, I would do so regardless of whether that president was a Republican or a Democrat. Recent narratives about my team's work are false and misleading, including stories about our collection of toll records. Toll records were sought for historical telephone routing information, collected after calls had taken place, identifying the incoming and outgoing call numbers, the time of the calls and their duration. Toll records do not include the content of calls. Those records were lawfully subpoenaed and were relevant to complete a comprehensive investigation. January 6th was an attack on the structure of our democracy in which over 140 heroic law enforcement officers were assaulted. Over 160 individuals later pled guilty to assaulting police that day. Exploiting that violence, President Trump and his associates tried to call members of Congress in furtherance of their criminal scheme, urging them to further delay certification of the 2020 election. I did not choose those members. President Trump did. I hope that my testimony today serves to correct these mischaracterizations about my work, and to that end, I welcome your questions.
You just made some pretty definitive statements about, your belief that President Trump was guilty of these charges. Is that correct?
Yes, I believe we had proof beyond a reasonable doubt in both cases. It's important to state clearly the amount of evidence we had and the basis for why we proceeded. Why we proceeded as we did is because we had a strong case, as I set forth in the final report.
Was there ever a prospect after you were appointed special counsel when you thought maybe you would not bring an indictment against President Trump?
Absolutely. When I took this case, I did not know enough about the facts or the law to have a judgment about whether we should proceed in either case, both cases, or neither case. I used my time when I was appointed to get up to speed on the facts and the law. But if the facts and the law did not justify going forward in this case, I would have been perfectly comfortable in doing that, as I have throughout my career in cases involving political figures when I was in public integrity and throughout my career. So I did not have a preconceived outcome in mind when I took this job.
Was there any point where you and your prosecutors that formed your team debated not bringing charges against the president?
Of course. I mean, that is the process of being a prosecutor, is you are analyzing evidence, you're collecting facts, and you're debating whether it's what the facts mean, the inferences to be drawn from the facts, or debating what the law is, and whether you can prove what you think is happening here or not. And so that was a continual process to decide if, in fact, we could go forward. And that, again, just to be clear, that is a process that I have undergone in my career personally and with prosecutors I've supervised.
But the president's statements that he believed the election was rife with fraud, those certainly are statements that are protected by the First Amendment, correct?
Absolutely not if they are made to target a lawful government function and they are made with knowing falsity. No, they're not. That was my point about fraud not being protected by the First Amendment.
I mean, there's a long list of disputed elections. I mean, the election of 1800, 1960, year 2000, where candidates believe they were wronged by because they lost. And there's a long history of candidates speaking out about they believe there's been fraud, there's been other problems with the integrity of the election process. And I think you would agree that those types of statements are sort of at the core of the First Amendment rights of a presidential candidate, right?
There is no historical analog for what President Trump did in this case. As we said in the indictment, he was free to say that he thought he won the election. He was even free to say falsely that he won the election. But what he was not free to do was violate federal law and use knowingly false statements about election fraud to target a lawful government function. Mm-hmm. That he was not allowed to do. And that differentiates this case from any past history.
A lot of these statements, though, people come into the Oval Office. I mean, the president isn't conducting his own due diligence. He is receiving people in his office that are telling him these things, whether it be Rudy Giuliani, whether it be John Eastman, whether it be Jeffrey Clark, whether it be Sidney Powell. And, for the most part, he is just receiving this information, and his statements are almost just regurgitating what these people have told him. I mean, isn't that the case?
No, and in fact, one of the strengths of our case and why we felt we had such strong proof is our witnesses were not going to be political enemies of the president. They were going to be political allies. We had numerous witnesses who would say, I voted for President Trump. I campaigned for President Trump. I wanted him to win. The Speaker of the House in Arizona, the Speaker of the House in Michigan. We had an elector in Pennsylvania who is a former congressman who is going to be an elector for President Trump, who said that what they were trying to do was an attempt to overthrow the government and illegal. Our case was built on, frankly, Republicans who put their allegiance to the country before the party. And so the president got information from people he trusted on other issues. He rejected it whenever it didn't fit him staying in office. And there was a pattern in our case where anytime any information came in that would mean he could no longer be president, he would reject it. And any theory, no matter how far-fetched, no matter how not based in law, that would indicate that he could, he latched onto that. And we were confident that we had very strong proof of that pattern. He also, I would just add, very consciously did not try to reach out to the sort of people who have the most expertise on these issues. He reached out to people who he thought could back him up.
Yeah, but let's be honest, the president doesn't reach out to anyone. People are brought to him. I mean, he doesn't, like, the people you mentioned that you were going to call a trial, those aren't, some, Pennsylvania Republican official. I mean, that's not somebody who was in the Oval Office communicating with the president, right?
Well, with respect to the Arizona Speaker of the House, that is someone the president reached out to. He also reached out to governors. He reached out to the governor of Arizona. He reached out, and again, Republicans, his allies. Our case was a case in which the president was preying on the party allegiance of people who supported him. And these are, again, the record is rife with examples of him reaching out to those people, inviting them to the White House. And another example, sir, is the folks from Michigan. He invited them to the White House. They told him, you lost because you underperformed with educated females. They told him that when he brought them there. And again, our case was filled with examples of that. I'm sorry?
Why didn't you charge any of those co-conspirators?
As we stated in the final report, we analyzed the evidence against different co-conspirators. My staff determined that we did have evidence to charge people at a certain point in time. I had not made final determinations about that at the time that President Trump won re-election, meaning that our office was going to be closed down.
Right.
The evidence here made clear that President Trump was, by a large measure, the most culpable and most responsible person in this conspiracy. These crimes were committed for his benefit. The attack that happened at the Capitol, as part of this case, does not happen without him. The other co-conspirators were doing this for his benefit. So in terms of why we would pursue a case against him, I entirely disagree with any characterization that our work was in any way meant to hamper him in the presidential election. I would never take orders from a political leader to hamper another person in an election. That's not who I am, and I think people who know me and my experience over 30 years would find that laughable.
So did you develop evidence that President Trump was responsible for the violence at the Capitol on January 6th?
So our view of the evidence was that he caused it and that he exploited it and that it was foreseeable to him.
But you don't have any evidence that he instructed people to crash the Capitol, do you?
As I said, our evidence is that he, in the weeks leading up to January 6th, created a level of distrust. He used that level of distrust to get people to believe fraud claims that weren't true. He made false statements to state legislatures, to his supporters, in all sorts of contexts, and was aware in the days leading up to January 6th that his supporters were angry when he invited them, and then he directed them to the Capitol. Once they were at the Capitol and once the attack on the Capitol happened, he refused to stop it. He instead issued a tweet that, without question in my mind, endangered the life of his own vice president. When the violence was going on, he had to be pushed repeatedly by his staff members to do anything to quell it. And then even afterwards, he directed co-conspirators to make calls to members of Congress, people who were his political allies, to further delay the proceedings. We sought an order in the DC case under Rule, I think it's 57.2, and we did that because Donald Trump was making statements that were endangering witnesses, intimidating witnesses, endangering members of my staff, endangering court staff. As you might remember, in the right around when the indictment was released, he issued a tweet saying, "If you come after me, I'll come after you." He called, in a tweet, he called General Mark Milley a traitor and mentioned that what he'd done in olden times, people would be put to death. As a result of the things he was saying, the judge in this case was received vile death threats. And with respect to DC, both the district court and the Court of Appeals, a panel of judges, found that his actions were in fact causing what we said they caused. They were causing witnesses to be intimidated and endangering people. And I believe it was the Court of Appeals also found that in addition to intimidating or chilling witnesses who existed, it would chill witnesses who had not yet come forward because they'd afraid that they would be next. So yes, we did file that, and I make no apologies for that. But as I said, one of the issues from my perspective was not only the witnesses who he had specifically called out and caused threats to be issued, this phenomena that was found by both courts, it was the result of that is that a rational witness who maybe had not come forward would be completely afraid to, because they would see that they would be next. And I think both courts agreed with that. In this particular case, there was a grave risk of obstruction of justice, given the obstructive conduct of President Trump as is set forth, for example, in the indictment in Florida. President Trump tried to obstruct that case in multiple ways. As I mentioned earlier, in the litigation we had regarding 57.2, we had numerous instances of him attempting to, in our view, intimidate witnesses or keep them from cooperating. And so given that reality, we did seek non-disclosure orders for the toll record subpoenas you're talking about.
Okay.
Mr. Smith, let's just start with the bottom line up front. One of your investigations focused on whether any person violated the law in connection with efforts to interfere in the lawful transfer of power following the 2020 election. Is that correct?
Yes.
At the conclusion of that investigation related to the interference in the lawful transfer of power following the 2020 election, when your office indicted Mr. Trump for his criminal scheme to overturn the 2020 election, did you believe that you had sufficient evidence to obtain and sustain a conviction against Mr. Donald Trump?
Yes.
For these charges stemming from Mr. Trump's criminal scheme to overturn the 2020 election, did you believe that you had sufficient evidence to prove these charges beyond a reasonable doubt?
Yes.
And we know that it's more than just a reasonable doubt. Did you believe that there were multiple substantial federal interests in proceeding with prosecuting Mr. Trump after he attempted to criminally overturn the 2020 election?
I did.
Now, the second investigation that you were appointed to lead focused on the possession of highly classified documents at Mr. Trump's Mar-a-Lago social club following his presidency. When your office indicted Mr. Trump for willfully keeping highly classified docs after he lost the 2020 election, did you believe that you had sufficient evidence to obtain and sustain a conviction against Mr. Donald Trump?
Yes.
And for these charges stemming from when Mr. Trump left the office in 2021 with these highly classified documents, did you believe that you had sufficient evidence to prove the charges beyond a reasonable doubt?
Yes.
And did you believe that there were multiple substantial federal interests in proceeding with prosecuting Mr. Trump for his unlawful possession of these highly classified documents?
I did.
How many years of experience do you have as a prosecutor, Mr. Smith?
In total, I've been a prosecutor a little short of 30 years.
Can you give us a high-level overview of the different offices you might have worked in as a prosecutor?
Sure. I started my career as an assistant district attorney at the Manhattan District Attorney's Office in New York City. I prosecuted local crimes there for 5 years. Afterwards, I became a federal prosecutor in the Eastern District of New York, which is in Brooklyn and Long Island, and I was there for about 9 years. I prosecuted larger, more complex cases when I was there. I was eventually the chief of criminal litigation there. I left that office to go overseas and work at the International Criminal Court for a little short of 2 years. I coordinated investigations of the Office of the Prosecutor there. I then returned to the Department of Justice, where I was the chief of the Public Integrity section of the Department of Justice, and I did that for somewhere between 4.5 and 5 years. I left Washington, D.C., and moved to Nashville, Tennessee, where I was the first assistant U.S. attorney and then later the acting U.S. attorney in the Middle District of Tennessee, which is in Nashville. I left government for the only time in my career. I was worked for a private company for a brief period of time, a period of months, and then I was offered a position by the State Department to serve as a war crimes prosecutor at a European Union war crimes tribunal in The Hague, the Netherlands, and I was there for a little over 4 years before I became special counsel.
And can you describe the types of cases out of all these years of experience? Just give us a broad overview of the seriousness of the case that you've brought in your career.
I've worked on all sorts of cases. Early in my career, I was a member of the offices in Manhattan, the domestic violence unit, and so I did a number of cases of people who are abusing domestic violence victims. Those are some of the most memorable cases in my career. I worked on gang cases, RICO gang cases, in the Eastern District of New York. I worked on the Abner Louima case, which was a assault of a Haitian immigrant by police officers. I did an international murder for hire case, other sorts of violent crime cases. I was one of the night of 9/11, I was part of the command center, and in the weeks afterwards, I was involved in responding to what happened on 9/11. After the Eastern District of New York, when I was overseas, I worked on war crimes cases that were in all sorts of different jurisdictions and all sorts of challenging investigative situations. And political corruption cases, obviously, when I was in public integrity and also in Nashville.
So taking all these cases you described, I heard cases about, gangs in New York. It sounds like there were war crimes cases, there were domestic violence cases you just described. Taking all that experience, when you finished your investigation in the special counsel's office, you believed that you had sufficient evidence in this case to prove Donald Trump committed those crimes after the 2020 election?
I did.
And you believe that you had enough evidence to get a conviction with Donald Trump willfully taking the classified documents after he left office in 2020 and returned to Florida in 2021?
That's correct.
Can you tell us why you felt it was important to make a request for a public hearing?
I'm proud of the work that we did at the special counsel's office. I'm particularly proud of the people I worked with, the career public servants I worked with, who've been vilified by President Trump and people who work for him, and I think someone needs to speak up for them.
Did you want to testify publicly to rebut some of these accusations from the president that you just mentioned about your investigation?
Yes, that's what I meant. Accusations not just against me, but against career prosecutors, career FBI agents who have served our country and who've been vilified wrongly. I think it's really important to correct the record on that.
Were you granted the request to testify publicly before this committee? Answer's probably obvious as we sit in this room, but were you granted that request?
No.
Were you given any reasons or provided any reasons why you were not allowed to testify publicly and directly to the American people?
I don't recall that.
Are you aware that even President Trump thought that you should testify publicly before our committee?
I heard that.
Yeah, just to make it clear for the record, Mr. Trump said, and this is a quote, "I'd rather see him," as in Jack Smith, "testify publicly because there's no way he can answer the questions." So let's turn to a few of those questions. So in this October letter to you requesting a transcribed interview, the chairman characterized your investigation as, quote, "politically motivated prosecutions of Donald J. Trump," end quote, and said you conducted a, quote, "unnecessary and abusive raid of the residence," end quote, of Donald Trump, and that claimed that you, quote, "manipulated key evidence in the investigation," end quote, among other claims. Do you recall these accusations to you in the letter from Chairman Jordan?
Yes.
The Republicans of our committee have made these letters to you public. You can read it on the committee's website, including these accusations that your office was weaponized. But this proceeding is behind closed doors, and Majority Counsel just warned you earlier about keeping the contents of this deposition confidential. Do you remember that warning that you received at the beginning of this deposition?
Yes.
So we will get into this in more detail later, but just to quickly touch on this, do you agree with the majority's characterization that your office was weaponized?
No.
Was your special counsel's office weaponized in any way?
No.
Did you conduct a politically motivated prosecution of Donald J. Trump?
I did not.
Would you like to have explained directly to the American people why these characterizations are not true?
Yes, and again, particularly as to the career prosecutors and agents who've been vilified.
Are you concerned that given that this deposition is not open to the public and the public cannot hear your answers or observe your demeanor or hear the way that you're responding to questions from the majority, that some of your responses may be selectively published or released in a way that mischaracterizes your answers?
I would hope that wouldn't happen.
But are you aware that's a risk of your testimony here today?
I'm sure that's possible.
If the case files were released, would they include any political considerations by you or your team as you investigated and charged these cases?
We did not consider politics. I did not consider politics, anyone's politics in charging these cases.
And that would be borne out, presumably, by the case files?
I'm not aware of anything in the case files that would contradict that.
Because it never happened.
It never happened.
Do you think that it's important for our democracy to hold free and fair elections without interference or obstruction?
Yes.
And theoretically, what happens if there is election interference and the people who are responsible for that are not held accountable?
It becomes the new norm, and that becomes how we conduct elections.
And so the toll on our democracy, if you had to describe that, what would that be?
Catastrophic. Well, as I said in the beginning of, I think, my opening remarks, there have been mischaracterizations about my work. We did our work in the best traditions of the department, and I know I keep coming back to this, but the attacks, the mischaracterizations that most offend me are not just prosecutors, but career FBI agents, support staff in the department. These are people who devoted their lives to public servants, to being public servants. They have not, they're not self-promoters. They're not people who like to go in front of the cameras and defend themselves. And I feel that they have been vilified in a way that I think is awful.
What's the effect of that on our democracy?
Well, I think it drives people away from public service.
Is it a form of witness intimidation?
I think it's even deeper than that. I think, you know, when we get to attacking the people who are the good guys,
Yeah.
I just don't know where that goes. It's counter to how I was raised.
And let me ask you, even after this deposition today, are you still willing to appear at a public hearing before this committee and speak directly to the American people about your investigation?
Yes.
But have you yourself been intimidated as a result of the actions that you took in this case?
I'm not going to be intimidated.
Have you been threatened?
Yes.
Have you learned of other persons, whether they worked under you as attorneys or other support staff? Are you aware of any threats that have been made against any of them?
Yes.
Ultimately, why did you accept the special counsel position?
Because I thought I was the right person for the job. I knew that this would be a challenging job. I knew it would be a job where whoever held the job, or whatever decision they made, somebody would want to attack them for that decision. And I felt that given my nearly 30 years as a prosecutor, it made me uniquely qualified to do the work.
I guess, how did you move forward consistently with those attacks while special counsel?
I think attacks and praise are noise, and as a prosecutor, I've learned to tune those things out. I'm more concerned, again, about the attacks on my staff, but for myself, I understand that that's can be part of the work at times.
Did you accept the role, as some have suggested, because you had animus towards President Trump?
No.
Did you accept the role, as some have suggested, because you hoped to influence the 2024 presidential election in favor of the Democratic nominee?
No.
Did you accept the role because you thought it would help the Democratic nominee by prosecuting Donald Trump before the election took place in 2024?
No.
I served on the January 6th Select Committee, and we spent a lot of time looking through the criminal statutes that may have been implicated in the attack on the peaceful transfer of power, the attempt to overthrow the election, and then the violent assault on the Capitol. And we, in our conclusions, cited a number of statutes which ended up, I think, being part of your investigation, including conspiracy to obstruct a federal proceeding, conspiracy to defraud the United States, false statements, and so on. But you added something which I think was very interesting, which was a conspiracy to violate voting rights, which is something that we hadn't done. And I wonder if you would take a moment to expound on why you thought you had sufficient evidence to prove beyond a reasonable doubt that there was a conspiracy to violate the voting rights of the people.
Sure. The right to vote in a presidential election is one of the most sacred rights that Americans have. And in this particular case, we had strong evidence that the defendants in this case sought to interfere with, obstruct, injure that right. We had evidence, and just a couple examples, where President Trump was asking local officials to find 11,000 votes. When you find 11,000 votes, you're diluting other people's votes. We had evidence that they were targeting certain states, and particularly certain parts of certain states, generally urban parts of states, to have those votes thrown out with no factual basis whatsoever. I believe we cited this in our final report, but there's even statements of the co-conspirators in this case, at least one that's coming to mind now, specifically saying we want to get rid of these votes. We want to subtract them. And diluting the vote count in that way, there's strong precedent for that being a violation of the statute that we charged.
There were 60 federal or state court decisions rejecting claims of electoral fraud, electoral corruption that had been brought by President Trump or his teammates. To what extent did that figure into your analysis of that problem?
Well, the lawsuits, we made clear in our indictment that there are proper ways to dispute an election, and asking for an audit, which President Trump did, and I believe in only 2 of the states that were in question, that's a way you can do that. Filing lawsuits, completely legal and proper way to do that. But in this case, those lawsuits were part of our proof that put President Trump and his co-conspirators on notice. The suits the results and the things that court said in finding those suits without merit put him, were one component of evidence that put him on notice that these allegations were false. Also, there were instances where there were protectual lawsuits. There was one lawsuit, for example, that was filed in New Mexico minutes before the deadline, so they could say there was a dispute in New Mexico so they could proceed forward with the fake electors ballot. There was another lawsuit in Georgia where one of the co-conspirators explicitly said in an email, we're on notice that the things in this lawsuit aren't accurate, so we shouldn't have the president sign a certification of this lawsuit. And then they played with the language a little and had him sign a certification nonetheless. And so these lawsuits, well, filing a lawsuit absolutely clearly is something you can do. They were probative evidence of the criminal intent in this case for those limited reasons I just suggested.
Have you ever prosecuted someone that you did not believe was guilty beyond a reasonable doubt?
Never.
Did Attorney General Garland or other DOJ officials direct investigative steps within your office of the special counsel?
No.
Did Attorney General Garland or other DOJ officials direct litigation decisions within your office?
No.
Did you experience Attorney General Garland or other DOJ officials interfering with your ability to conduct this investigation?
No.
Did President Biden ever give you any instructions about what you should or should not do related to these investigations?
No.
Did you ever speak to President Biden about these investigations?
No.
Your lawyers lost their security clearance, is that correct?
Yes,
People who worked under you were fired, is that correct?
that's correct.
You're here today on a deposition that Sherman has brought you into, but I wouldn't give you a public hearing, is that correct?
Yes.
Did you see the comments by the President's Chief of Staff talking about retribution?
I did.
So, everyone was fired. You're here on a deposition. Your lawyers lost their security clearance. It seems like it meets not only the definition in Webster, it seems like this is exactly what Trump's Chief of Staff was talking about. No?
I have no doubt that the president wants to seek retribution against me. I have no doubt that that's the intent. So I am eyes wide open that this president will seek retribution against me if he can. I know that. I don't, frankly, connect that with this hearing. I don't have any connection. I came here, I was asked to
No,
come
you
here.
think there were zero conversations between the White House and Chairman Jordan?
I don't know, but I'm here in good faith, and I was asked to come testify. I offer-
Did the Attorney General or any other DOJ official ever press you to be more aggressive in your investigation of President Donald J. Trump?
No,
Did the Attorney General or any other DOJ official ever suggest that you were expected to bring charges against President Trump?
no,
Did anyone from the White House, including President Biden, ever tell you they expected you to bring charges against Donald Trump?
no.
When you eventually did bring charges against Donald Trump, how did you make that decision? Walk us through it at a high level, if you don't mind.
Sure. It was based on the facts and based on the law. I ultimately made that decision, but I consulted with my team of prosecutors on that case, who were outstanding public servants, people with great experience in complex investigations. I took their advice and counsel in making that decision, and I tried to consider all factors, including both the strength of the case that we believed we had, possible defenses, all things of that nature.
So which based on what you just said, it sounds like you made this prosecution decision based on the evidence in the law. Is that correct?
That's correct.
What would you have done if you felt any improper pressure from a DOJ official or the White House?
I think people who know me and have known my reputation would know that that would not end well. Someone tried to pressure me to move a case in one direction or the other where wasn't supported by the law. I wouldn't stand for it, and I would also say the people who worked in my office wouldn't stand for that either.
Speaker McCarthy's co-records, after he became speaker, And you sought records from November 2020 through January 8th, 2021. Like, what were you looking for with his records? Like, what did you do with the information you obtained?
Okay, so what, the relevance of those records, there'd be several examples, but his contacts with either co-conspirators, the president, or conduits of information to the president was relevant to our investigation. And an example I could give you is on January 6th, we had information from Mark Meadows, who was present for a call where Congressman McCarthy was asking for help. He was asking the president to come to his aid while the Capitol was being seized. Getting the exact toll records for when that happened was relevant for our investigation, both to question other witnesses about, so we had an accurate timeline, and also to corroborate that the call happened at approximately the time witnesses said it happened.
But it's pretty significant to subpoena the Speaker of the House's toll records, right?
We followed department policy and we followed all legal requirements in getting those records.
I mean, well, you know, to get the information you're looking for, nobody disputed the Speaker and the President were having communications on January 6th. So one way you could have gotten that information is you could have asked the Speaker's lawyer to look at his phone records and to give you the information you needed, right?
Well, you say now that nobody's disputing, but my experience in criminal investigations is that people often at trial dispute things that you never thought were going to be in dispute during the investigation. And so when I conduct a criminal investigation, I don't assume there will be no disputes. Having a record that is a hard record about a time, and the timeline of that afternoon was particularly important because that violence started. The president refused to stop it. He endangered the life of his vice president. Then he's getting calls, and not calls from Democrats, not calls from people he doesn't know, calls from people he trusts, calls from people he relies on, and still refuses to come to the aid of the people at the Capitol. That's very important evidence for criminal intent in our case. Mark Meadows, when we interviewed him, he referenced the fact that afternoon Chairman Jordan had been in contact with the White House, and like Congressman McCarthy's contact with the White House, it was relevant because, and again, Meadows stated this, that these were supporters, these were credible people that the president relied on. And what I recall was Meadows stating that I've never seen Jim Jordan scared of anything. And the fact that we were in this different situation now where people were scared really made it clear that what was going on at the Capitol could not be mistaken for anything than what it was. And it goes back to that sort of information from someone who is a credible source to the president, proving that actually happened and that there's actually a record of that call and exactly when it happened and what actions happened after that or didn't happen after that, extremely probative to our case.
Members of Congress and senators are up in arms that this happened to them, and they're seeking accountability. You know, who should be held accountable for answering these questions?
Well, I think who should be accountable for this is Donald Trump. These records are people, in the case of the senators, Donald Trump directed his co-conspirators to call these people to further delay the proceedings. He chose to do that. If Donald Trump had chosen to call a number of Democratic senators, we would have got toll records for a number of Democratic senators. So responsibility for why these records, why we collected them, that lies with Donald Trump.
Where did the alternate electors case stand, you know, when you became the special counsel in November of 2022?
So the fake elector scheme was part of what I was investigating, and it ultimately became part of the charges in the case.
Okay. Seems like the alternate electors matter, it seems like it was subject to a lot of starts and stops. And wanted to know whether, after you became the special counsel in November of 2022, were there any starts and stops, or was that full speed ahead on that probe?
That was a part of the case that we investigated from the time I started until the indictment. It ended up being one of the most powerful parts of the case. We had electors who were going to be witnesses. I referenced earlier a congressman from Pennsylvania who had said this was an attempt to overthrow the government. We had other electors who said, I was told that this would only be used if we won in litigation. And obviously the record in our case showed that the co-conspirators were trying to use their elector votes despite that fact. And again, this goes to the point I made earlier. These are people who wanted to be electors for Donald Trump. They are not people who are opposed to him. They were not people who are from a different political party or enemies. And so the fact that we had elector witnesses like that, who felt either they'd been misled or they felt that this whole effort was an attempt to overthrow the government, I thought that was pretty powerful evidence. And so we moved that part of the investigation forward with the rest of the case. So I will just say, though, that one of the things we were investigating was things that happened in Fulton County. Particularly, there was an election worker by the name of Ruby Freeman, her mother, and she was the mother of a woman named Shay Moss. They were people that Rudy Giuliani and Donald Trump targeted with absolutely false claims of election fraud, claims that Rudy Giuliani later admitted he didn't have evidence for, claims that he was held liable in defamation for, caused them to endure all these sort of vile threats. And that whole episode, as well as sort of the claims, the false claims about the vote count in Fulton County, we did look into that and collect evidence. I don't have a recollection, as I sit here, that we interacted with the Fulton County DA's office for that, but if we did, it would be only for that. I have not worked in big law. I've been a public servant my whole career. That's the world I know.
Okay. By contrast, the lawyers on the January 6th committee, I mean, they leave the Hill one day and, they're immediately gobbled up by big law very quickly. That just doesn't happen with Republicans. Would you agree?
That Republicans don't get jobs as lawyers? I mean, I'm sorry.
At big law firms.
I don't actually know that that's true. I mean, again, this isn't a world I have worked in, but I think there are Republicans at big law firms.
Okay.
Did Donald Trump and his co-conspirators try to reach out to members of Congress before January 6th and on January 6th of 2021?
Yes.
Can you tell us a little bit about what your investigation uncovered regarding communications with members of Congress that's related to the attack on the Capitol on January 6th?
There was pretty extensive contact with members of Congress. There were instances of members of Congress, again, specifically on January 6th, but also before that, where either they were reaching out to the White House or the White House was reaching out to them, and through conduits to the president, including, as I said, Mark Meadows.
Okay. And what was the nature? Let's start with before January 6th. What was the nature of some of these communications with the White House or with co-conspirators of Donald Trump leading up to January 6th and members of Congress?
Well, it varied. Sometimes the communications were relevant to us to show that people were telling Donald Trump that the things he was saying were not true. Other times, they were evidence of the false nature of the things that we're saying. So, for an example, would be there are 2 voicemails that Rudy Giuliani left for senators, and those voicemails show him saying things that were not true, using knowingly false claims to try to get those senators to further delay the certification of the vote.
You just mentioned that there were instances before January 6th of members calling the White House and I'm summarizing, to basically express that some of the claims the president and his co-conspirators were making were not true. Is that what you just said?
Well, I should be specific. There were a variety of reasons that, and I'm not trying to say that anytime someone contacted the White House, they were involved in a crime themselves or doing anything improper. But how this conspiracy that was trying to stop the lawful transfer of power, how that worked, it was important for us to understand. We had evidence from Department of Justice officials that Donald Trump said to them, just say the election is corrupt and leave the rest to me and the Republican congressman. I think given that was the perspective that Donald Trump had, our view is that the case we would have presented at trial would have been Donald Trump preying on the party allegiance of people in his party. And people like the vice president didn't agree to that. People like the elector from Pennsylvania I mentioned didn't agree to that. People like the Speaker of the House in Arizona didn't agree to that. But the extent to which those contacts were happening was relevant to our investigation.
Okay, so let's dig down a little bit in that. Let's start on January 6th. So I believe in the evening, did your investigation uncover or learn that Mr. Trump personally called members of Congress on the evening of January 6th?
Yes.
Do you remember who those members were?
I'd have to look at the records to be sure, but to the best of my recollection, he was trying to get in touch directly himself with Senator Hawley and Senator Haggerty. And then there were several senators who he directed Rudy Giuliani to get in touch with.
And who were those senators that Mr. Trump directed Mr. Giuliani to get in contact with, to the best of your recollection?
To the best of my recollection, and this comes from a email, or I think it was a text maybe, that Boris Epstein sent to Mark Meadows, and it basically said something to the effect of the president told the mayor to call these senators and they needed numbers. And what our investigation ultimately showed was they sent that text after they'd already started trying to call members and didn't think they had, and ended up understanding that they didn't have the right phone numbers. In fact, the message that they left for Senator Lee, which he voluntarily provided to our office, that was meant for Senator Tuberville, I believe. And the message that he left for Senator Sullivan, I believe it was for Senator, the name's escaping me now, but it was another senator that he meant to call. We had also interviewed Boris Epstein before these subpoenas were issued. He corroborated that they were, in fact, trying to call senators. He dissembled and tried to imply that the president hadn't directed him to do it, even though there was a text message saying specifically that they had. But he agreed that they tried to call these senators and that they had certain senators' numbers themselves, and so they didn't need those numbers. And that would be, I believe it was Senator Cruz, and possibly, I think he said they possibly tried to call Senator Graham as well. We also, in the course of the investigation, interviewed Rudy Giuliani. And one of the things that we asked him, if you recall, in the message, I can't remember which senator it was for, but in the message that he left, he said, referenced the fact that he was calling on fellow Republicans. And in the interview, we asked him, why did you say you were calling on your fellow Republicans? And he said, well, I wasn't going to be calling Democrats about this. Even some Republicans wouldn't go along with this. And so, of course, I would call only Republicans. And in fact, that was consistent with our investigation throughout, that the people that President Trump and his co-conspirators reached out to were people who they thought would go along or help them because of party allegiance. And Giuliani in particular would reference that he expected their cooperation because they were Republicans. There was one particular meeting that he attended where he got a hostile reception because he had no evidence to back up the fraud claims. And he said something to the effect of, "I thought we were all Republicans here." And so that was a theme throughout the case, and it went to the strength of the case that we had because the witnesses we were going to call were the people that the president reached out to sort of further this criminal scheme.
Why? So did you recall any evidence when you were talking to Mr. Giuliani that he truly believed all the voter fraud claims that he was putting out around the country?
Our evidence was he did not. And in fact, when we interviewed him, he disavowed a number of the claims. He claimed they were mistakes or hyperbole. Even the claim about Ruby Freeman, where he, basically destroyed this poor woman's life by claiming she was a vote scammer. President Trump did the same thing in a recorded call with the Secretary of State. He disavowed things he'd said in that interview.
Were you able to find out what the communication was between Mr. Meadows and Mr. Bannon and potentially Mr. Stone on the evening of January 5th at the so-called War Room at the hotel?
I think he was in touch with Bannon, but I don't recall specifically the answer to that question.
Mr. Bannon made an extraordinary video basically predicting the events of January 6th on the day before. Were you able to discover, either by interviewing Mr. Bannon or those who had knowledge of what he was doing, how he was aware of the riot before it happened?
We did not interview Mr. Bannon. I believe that particular statement you're talking about would have been part of our proof, and my recollection is that we had evidence that would indicate from some point, not immediately after the election, but shortly thereafter, sometime, might have been closer to December period, that Bannon, who had been out of touch with President Trump for some period of time, got back in more regular touch with him at some time. And in fact, this is reminding me, my recollection is that we had a text thread that between Bannon and Epstein that went through a lot of this period. On that text thread, I believe it was the evening of January 6th, right around the time the senators' calls were occurring at the direction of the president. And there was an exchange between those two wherein I believe it was Epstein asked Bannon, "Are you in touch with him?" And the answer was affirmative, and it was something to the effect of, "He's still on fire." And that's right at the same time that these calls are happening, after he refused to do what he could to stop the attack on the Capitol, after the tweet about Mike Pence.
In December, there were several meetings in the White House where efforts were to overthrow the election were discussed in terms of the fake elector scheme. The president issued his tweet calling the mob to Washington that it would be wild. Did you identify members of Congress who participated in any of those meetings
Participated in meetings at the White House.
in December?
I remember there was a meeting with Sidney Powell where there was a discussion about whether she would be appointed a sort of special counsel to sort of have this role that would assist Trump in pushing these claims of election fraud that were false. My recollection of that is the meeting ended, I believe, with President Trump saying, "I want her in that position," but then it didn't happen because she didn't fill out the paperwork, clearance paperwork necessary for that. There's a record of this in our files. I remember certain individuals. I think Mark Meadows was there. An individual by the name of Eric Hirschman was there. I think Rudy Giuliani was there. There was a number of people there. I'm not remembering Whether, if there's anybody in particular, you can ask me and I can see if I could remember, but that's what I remember now, Sabina.
And let's fast forward to, say this would have gone to a trial. How would you, in your experience, have used this type of evidence in a trial?
Oh, it would have been relevant in a number of ways. So it would have been relevant, you could put it together in a summary chart to show the series of contacts, and it could be relevant to show the campaign that evening to reach out to senators to delay the proceedings. Could also be relevant to show, for example, on the afternoon of January 6th, of notice that there was notice that violence was going on. Congressmen, both Republican and Democrat, and the vice president were in danger. That text records would make that incontrovertible that those calls actually happened. They'd also be relevant for examining witnesses, whether it would be a prosecution witness who might not remember exactly when a call happened, or a defense witness, for example, if any of the co-conspirators were to testify, which, as I mentioned before, was something we would have welcomed. We would have had toll records to question them about the calls that they made, the calls that they received, things of that nature, which, in my experience, can be very effective.
And I believe you said some of the false claims he was putting out created a certain level of distrust about the validity of the election of 2020. Do you recall saying something like that as well?
Correct. That's alleged in the indictment. Correct.
So I want to start with how that level of distrust was created. In your report, you say, and this is a quote, "The through line of all of Mr. Trump's criminal efforts was deceit, knowingly false claims of fraud." Can you generally describe some of these knowingly false claims of fraud that were spread after the 2020 election?
Sure. There's a number of them. And you know, part of the explanation is why they're false. And so, you know, just off the top of my head, an example is he was on notice in this election that in Pennsylvania, for example, that he would be ahead in the vote count for a period of time, and then when the mail-in ballots were counted, his lead would dissipate. He chose to represent that phenomena that he'd been briefed on, that was normal course of an election, that all sides knew that that's how it was going to be. He chose to present that as evidence of fraud. And to people who are not maybe as informed as him, or informed as his campaign managers who told him these things, that's the sort of thing that creates distrust. There were fraud claims in, you know, Michigan, Georgia, where he was specifically disabused by people he trusted, by political allies, by the people, when he chose to call them, who are best situated to know. In Georgia, I'm thinking of the Secretary of State. He reflexively rejected those things and continued to state false things after he'd been told that repeatedly that they weren't true.
And why was it important? Like, it probably goes to the mindset, but why was it important of all of these repeat statements from individuals that Donald Trump's claims were untrue? How did that play into your overall investigative findings?
Well, I think the pattern and the depth of the pattern and the length of the pattern was pretty damning evidence that he knew these things were false. He only brought fraud claims that involved states that he'd lost. He only approached people generally who had party allegiance to him. When he was told that a fraud claim wasn't true, he didn't stop making it. Another example I can give is that Sidney Powell, who's alleged as one of the co-conspirators, was part of his team at the beginning of this conspiracy. Shortly after, she began making statements that really nobody could credit, that were facially false. And at some point, Giuliani made a statement that she wasn't on the legal team anymore. And Trump, at one point, was on a call, President Trump, where he basically, if I recollect it right, he muted the call and said she was crazy. But then after that point, he continued to promote her fraud claims and lawsuits. He considered putting her as a special counsel, even though he'd admitted, you know, he used the word crazy, and the statement she was making could, by any reasonable person, be viewed as true. And so I think that sort of like claims that were so outlandish and so just fantastical, continuing to push those sort of claims after they've been disabused with strong evidence of our case.
One of the bigger parts of your report and what you've talked about here today comes down to the knowledge, Mr. Trump's knowledge that he had lost the election. I know you've talked about it at various stages of today, but I would just like a pretty clear answer, if you don't mind, about what evidence did you collect about Mr. Trump's knowledge that he had indeed lost the election of 2020?
Okay. Well, there are two types of knowledge. One, that he lost the election, and another, that the things he was saying, the fraud claims were in fact false.
And I want to start with the first one, that
Yeah.
you said that he had lost the election.
Yeah, I think, again, it's the same sort of bucket of evidence that he was repeatedly told by people that the very fraud claims that would change the outcome were not true. As you may remember, when he was told by his campaign team, in essence, that if you can't win Arizona, you can't win the election, and then he lost Arizona, he changed out that team and went with Giuliani and his group. We also had statements from other individuals. I believe it was General Mark Milley who said he was going to leave this for the next guy. There was another staffer who overheard him saying that something to the effect of, and I want to make sure I'm not inaccurate here, it's in our final report, but basically, like, you keep fighting regardless of whether you won or lost, things of that nature, which were corroborative of the very strong evidence of that the things he was saying about about the election claims were not true.
And then you said earlier, when I asked you the original question, I thank you for parsing out the various knowledge, right? The second part was that Mr. Trump knew that his claims were false. And in the report, you say that Mr. Trump, and this is a quote, knowingly made false claims. So I'm assuming that talked about the false claims he made after he knew that he had lost the election. Can you describe or summarize some of these false claims he made to the American public after he knew that he had lost the election?
Sure. These would be false claims about dead voters. It would be false claims about underage voters. It would be false claims about illegal alien voters. The false claims were generally, as a general matter, about urban centers where he had lost the vote in a particular state that was otherwise close by a lot. Yes, and again, these were claims that were rebutted by people around him who knew that they were false, and in many cases told them they were false.
Did President Trump ever acknowledge, and I believe you talk about it in this paragraph, but did President Trump ever acknowledge that he knew that he had actually lost the election of President Biden?
Yeah, so this paragraph references different statements that he made in the presence of other people. One is that it doesn't matter if you won or lost the election, you still fight like hell. And then the other was, can you believe I lost to this effing guy?
So,
Referring to Joe Biden.
Mr. Trump, or how could you, what's a way you could have argued this admission from Mr. Trump to a jury?
Well, I think I saw these admissions as corroborative of the larger case. We would have presented what I viewed as very strong witnesses from each state to explain how the elections occurred in that state and why the events, the outcomes were trustworthy, and debunking various fraud claims that President Trump made. We would have presented the false claims that he made repeatedly, interspersed with debunkings to him, or other evidence that showed they weren't true and that evidence got to him. This sort of evidence would corroborate that, but it would sort of be the cherry on top, if you will. The evidence that I felt was most powerful was the evidence that came from people in his own party who, as I said earlier, put country before party and were willing to tell the truth to him, even though it could mean trouble for them. Electors were told that they would only be used in these circumstances, and as you know, other ways of overturning the election fell away, and as President Trump and his co-conspirators became more desperate, they came up with even more obviously illegal ways to try to stay in power, and it eventually devolved to, let's just say that these are the electors, regardless of whether any court has said so, the governor has said so, the people of the state, and most have said so. They didn't go back to electors and say, hey, we're going to use your, I know we told you we were only going to use this if we won a lawsuit. They just went ahead and used it. And I think, again, even among the fake electors, there would have been witnesses. I'm thinking of one witness in particular in Georgia who I thought would have been very powerful of, I would never have done this if I thought they were going to use my name to overturn the will of the people, just because one person said so.
That in December, there was an effort to create fake electors. And in fact, on December 14th, when the electoral colleges meet in all the state legislatures, there were 16 fake electors in the basement in Michigan, and 4 of them tried to get into the Capitol to overturn the election. Did you look at that whole phenomena?
We did.
And what was your conclusion? What was the, how would that have played, if at all, in your prosecution?
Well, I think that event you're referring to, and I think we interviewed some of the law enforcement officers who were there that day when they were trying to get in. What they were doing and what the email traffic among co-conspirators showed is they were trying to mimic the procedures that are required by the Electoral Count Act, but they couldn't mimic them. And if I recall, the email traffic on this started with, we have to follow these procedures. And then when it became clear they couldn't follow all the procedures, it was like, well, do the best you can to follow as many as you can. And so I think, if I do recall, certain states, it may have been Michigan, that the electors had to convene in a certain government location. And so as a result, I believe there may have been a state official involved in trying to get them into, if I'm thinking of the right situation, get them in there so again they could mimic the procedures, even though they were not the electors that represented the will of the people, how the vote was actually counted.
Thank you.
Pence, what did Donald Trump want Vice President Pence to do to overturn the election results?
Well, ultimately, he wanted him to just hand him the election to say he won. There were different proposals that President Trump and his co-conspirators put to Mike Pence, but in essence, he wanted Mike Pence to impose his own choice about who should be president over the will of the American people who voted in the election.
Was one of those ways that Donald Trump tried to pressure Mr. Pence was to reject the lawful electors' certificates of their votes during the electoral counting process? Was that one of the ways that you recall?
That's correct.
How did Mr. Pence respond back to Mr. Trump's pressure about rejecting the lawful elector certificates?
I think Mike Pence, Vice President Mike Pence, falls into the category that I described before. He did something that was very hard to do. He went against his party. He paid a price for it. But I think, again, someone like that putting country over party, I think he would have been an effective witness. He did not agree to go along with it.
You just talked about with Mr. Pence's response to President Trump's pressure. Is this yet another example of evidence that showed Mr. Trump knew or should have known that what he was saying to the American public was false regarding the election of 2020?
Yes. The vice president was one, and this is alleged in our indictment and our filings, was one of several people saying he was not seeing the outcome determinative fraud that Donald Trump was claiming.
And what would have happened if Vice President Pence would have gone along and refused to count the lawful elector certificates?
Well, thankfully, we don't know, but I would say that he and the other people who stood up and said, I'm not going to do that, may have changed the course of history in terms of our country, of having an election where someone took power in our country who didn't actually win the election. So, as I said, I think it took a lot of courage on his part. He's also someone who, as you all know, when the attack on the Capitol happened, he wouldn't leave. People wanted him to leave. And I think, again, that reflects very well on him. I think all of us want to make sure people's First Amendment rights are not abridged in a way that they shouldn't be. I think I certainly feel that way. I'm sure everybody in this room feels that way. But there is a very clear carve-out for fraud in our case law. Supreme Court, I think there's one case, is the Stevens case, talks about that, and there are others. And so when you're committing a fraud, meaning you're not just saying something that's untrue, you're saying it knowing it's untrue or with reckless disregard for the truth, that's not protected by the First Amendment. People commit crimes all the time using words. And when someone commits a fraud, an investment fraud, or someone commits an affinity fraud where you try to gain someone's trust, get them to trust you as a general matter, and then you rip them off, you defraud them. That's all words, but it's not protected by the First Amendment. And in a lot of ways, this case was an affinity fraud. The president had people who had built up trust in him, including people in his own party, and he preyed on that. Some people wouldn't do it, others would. We're lucky that enough wouldn't, that the election was upheld. So I made it clear from the day that I began at the special counsel's office, this was going to be a nonpartisan investigation. This was not, the politics would play no role in it. I think everybody in my office agreed to that. I can tell you of one incident where we were reviewing the email chains of agents who might be witnesses in the case for Jiggly review. And we needed them to give us all their emails. An FBI agent who was working on the case took that direction and actually provided us with his private emails with his family. We didn't ask for that, but he gave us his private emails. In one of those emails, and I can't remember if I saw this or my deputies saw this, he was having a dispute with family members where it was about January 6th. Once I saw that or heard about that, I decided he could no longer work on this investigation. And I think that was consistent with how I ran the office. And I want to also be clear, I never saw that agent do anything that I considered partisan. But just to make 100% clear to my staff, and this is an agent who volunteered this beyond what was required. I wanted to make very clear that anything like that was not going to be part of our investigation.
Did you think it was important that that evidence be in the public realm before the election? So, people could make up their mind about who they were going to vote for?
No, I did not see it as our role to provide evidence for people to make their voting decisions on.
Do you think that you would have recommended, a jail sentence, prison sentence, if he was convicted?
I'm not going to speculate on that because that would require a very detailed analysis of the sentencing guidelines factors, of what he was convicted of any mitigating factors. That's not something you do off the cuff, whether someone should be incarcerated or not or how long. That's not something I would do without significant analysis.
And had your office undertaken any type of analysis on that front?
In terms of a thorough analysis, I don't recall anything like that. I'm sure that we knew how much the sentence could be in each individual thing, but I certainly had not turned to thinking about what sentences should be. As a rule, I don't do that until there's a conviction in a case.
Okay, and what would have the sentence have been for the charges that you indicted for?
I'm not going to speculate. If we sat down and went over the sentencing guidelines, we could talk about what that would be, but I have not done that analysis, and I haven't thought or looked at or thought about that issue.
Would that analysis have yielded some jail time, or recommendation for some jail time?
Again, I'm not going to speculate on that because, as I mentioned earlier, you only get to that if you try your case and you prove it beyond a reasonable doubt. We did not do that in this case. There was no trial, and we didn't do that.
Mr. Smith, do you believe that the Supreme Court's decision on executive immunity constitutes an exoneration of President Trump's conduct in the months and weeks leading up to January 6th and then January 6th.
No.
Would you just explain that for us, why you don't see that as an exoneration for what he did?
Sure. I understand the Supreme Court decision. If I just go back for a second, this was an issue we litigated in the district court. The district court agreed with us. We litigated it in the Court of Appeals. The Court of Appeals agreed with us. We litigated it in the Supreme Court. The Supreme Court majority did not agree with us. They took a view of executive power that was more expansive than what we argued. I disagreed with it for the reasons we set forth in our brief and the reasons stated by the dissent in the case, Justice Sotomayor, but it is the law of the land. What my office sought to do in responding to that was to follow the law and see, do we still have a case? And I think the evidence that we had after that decision remained powerful. I talked earlier today about state officials who put allegiance to the country before party. Those officials from Arizona, Wisconsin, Michigan, Pennsylvania, all those, I'm sorry.
Georgia.
All those witnesses, right, all those witnesses would still be available to us. The heart of our case would still be available to us. And I think it's important to know that, well, you know, our view was that he abused his authority in the Justice Department to effect, as one way to effectuate this scheme. This was about him as a candidate trying to say he won an election he didn't win. And so having to frame this in that manner, obviously it limited some of the evidence. That's why we had to supersede the indictment. But I don't think it was an exoneration because I still believed that there was substantial evidence that would allow us to prove the case beyond reasonable doubt. I think, and this isn't just me, the Court of Appeals in this case, when we litigated it, said that if the things we alleged were proven, it would amount to attack on the structure of our democracy. Those aren't my words, those are the court's words. And so whether a case is of that import or of less, I think you go about it the same way, but obviously the consequences for our country are quite different.
Have you made any statements, or are you willing to make any statements on the firing and removal of the Department of Justice prosecutors who worked on January 6th, on people at the FBI who were involved in the FBI investigation, or on the president's mass summary pardon of 1,600 January 6th insurrectionists and other people involved?
Yeah. I think what has happened to career prosecutors and career FBI agents is awful. It's contrary to the rule of law. It's contrary to who I think we are as a country. One of the agents on our case, he served his country overseas multiple times, war zones. Family of dedicated public servants, wife's family, dedicated public servants. He got fired for doing his job 2 weeks after his wife died. I went to the funeral. I saw his family. I saw a church full of public servants. No reason a person like that should have to go through that. And I'm getting emotional. I'm sorry about that. But I just think that's wrong.
A little bit. If individuals are fired or lose their jobs simply for taking part of an investigation into someone who is an authority figure or in a high position of government, how does that impact our democracy?
Well, if you take the position that you cannot work in the federal government unless you have a political allegiance to the president, I think there are many harms to that. Our country tried that in the past. It's called the patronage system. And what we learned in our history is, and this would be, if it's a Democrat or Republican, would not matter. But what we learned is that those systems are rife with not only corruption, but with incompetence. Because the people who have these jobs, they didn't get them because of merit, because they dedicated their career to learning national security law, to learning how to properly investigate a case. They got their jobs because they're loyal to a particular person. That's not fair, but it also makes for people who really don't know how to do the work. And so I think that's a danger to the country. It saddens and angers me in the short term, but I think there are great costs to us long term if that's the direction we go in.
Let's do the job. What types of dangers do you see if this continues?
Well, I've just seen career prosecutors who have served, again, Republican and Democratic administrations over and over again. These are the knowledge sources in the department in different areas. These are the people who mentor young lawyers. And when you take them away, those young lawyers don't have anybody to learn from. My experience in the department, again, doesn't matter, the administration, these are not partisans. They're people who have decided they don't want to make a lot of money. They're not looking for fame. They just want to do good work. And I think when you lose that culture, you lose a lot.
I guess, are you aware of some of the firings or dismantling that's been going on with the public integrity section since the beginning of 2025?
Yes.
Do you care to elaborate on how this might affect the investigations or prosecutions of public corruption and bribery case that you just mentioned?
Well, I'm concerned that the department is going to cease to have an ability to prosecute public corruption, that there's going to be the expertise necessary to do that, or the direction to do that. And so, again, I think there's short-term costs and long-term costs.
Well, we're going to turn now to the classified documents investigation. We want to ask a few questions. Can you summarize for us, I know we haven't gotten to it very much, but can you summarize, starting with page 38 through 52, the charges against Mr. Trump and his co-conspirators related to the classified documents that he kept after leaving office in January of 2021?
Sure. Counts 1 through 32 charge Donald Trump with willful retention of national defense information. This regards classified documents. The remaining counts relate to, and they charge Donald Trump, Waltine Nada, and then other counts, I believe, also charge Carlos de Oliveira with various counts relating to attempting to obstruct that investigation, whether it be moving boxes so that those boxes wouldn't be found by an attorney who was doing a search of documents to return to the government, and also false statements by, I believe, both Mr. de Oliveira and Mr. Walt Nada, and I think there's also in here counts related to attempts to destroy video footage and delete security camera footage related to all three of the defendants. The indictment lays out that these boxes were moved around to various locations where lots of people had access to them. After they were on the ballroom stage, they were in a business center, and then moved to a bathroom and shower in the lake room. And I believe it's blurred out in this picture, but one of the classified documents that's actually charged in the case is visible in this picture. I think it's count 8, and this is a room where others had access to. Obviously, someone was able to go in there and spill this box of documents, and Mr. Nada took a picture of it, so I think it shows how accessible these documents were and the sort of manner in which they were, the care with which they were kept.
The court-authorized search of Mar-a-Lago has been subject of lots of discussion on this committee. I think an important question to ask, I'm going to reference paragraph 38 on page 17, was whether any government agencies or individuals within the government had tried or attempted to collect the classified documents from President Trump after he left office in January of 2021.
Yes. Sticking specifically to the indictment we have in front of us, beginning in paragraph 38, these paragraphs detail efforts by the National Archives and Records Administration to recover, I think originally, it wasn't to recover classified documents, it was to recover presidential records that were missing. In the effort to do that, and as you can see, that took several months. What they eventually got was a number of boxes. I believe it was, I think he said it was going to be 12 boxes, and then it was 15 boxes, yes. What came back was a large number of highly classified documents, including secret documents, top secret documents being documents that would cause grave danger to the national security.
Speaking to the indictment, can you summarize for us the efforts that the defendant took to conceal the boxes of classified documents in Mar-a-Lago?
Sure. So paragraph 53 references the fact that a grand jury subpoena was issued on the 11th of May, and that two attorneys representing Donald Trump informed him of the subpoena, and he authorized them to accept service. So he was on notice of the subpoena at that point. 11 days later, Walt Motto, who was the parlance, I think, is his body man. He'd previously been a valet for him at the White House. Went into the storage room, which was the landing place, the last place these boxes were, and left 34 minutes later carrying one of President Trump's boxes. The next day is the day that Donald Trump met with his attorneys to discuss the subpoena. They told him that they would need to search for the subpoenas and provide a certification to show that they were in compliance with the subpoena. And below that is a number of statements that one of those attorneys memorialized that Donald Trump said during that conversation. And paragraph 56 would be as well. Paragraph 57, Donald Trump confirmed his understanding that one of those attorneys would return to the club on June 2nd to search for any documents with classification markings to satisfy the subpoena. And Donald Trump indicated that he actually wanted to be there that day when he returned to look at the boxes. He told the second attorney that second attorney didn't need to be there. And so after that meeting, he had planned to depart Mar-a-Lago, but he changed his summer plans to be there on the 2nd when the first the attorney came to review the boxes.
And just to confirm, Mr. Nato moved these boxes just a day after Mr. Trump met with his attorneys about responding to the grand jury subpoena, is that correct?
Well, yes, he actually, the first day that is listed here is in paragraph 54, when he moved the first box, and then 3 boxes were moved on the 24th. On the 30th, Trump and Nauta spoke by phone for about 30 seconds, and very shortly after that, over a period of a little less than 2 hours, Nauta moved another 50 boxes from the storage room. That same day, there was a text exchange between Nauta and the president's wife, and in that, I'm summarizing here, but it's on paper. She was saying, we're not going to have room for all these boxes on the plane, and Mr. Nauta replied, I think he wanted to pick from them. I don't imagine him wanting to take the boxes. He told me to put them in the room and that he was going to talk to you about them. And then on the 1st, 11 more boxes were moved out of the storage room.
So let's, that's a lot of movement of boxes, right? It makes sense that it's under the concealment of evidence section of your indictment.
Between May 23rd and June 2nd, NAUDA, at Trump's direction, moved 64 boxes from the storage room to the residence. And then afterwards, NAUDA and De Oliveira returned to the storage room only 30 boxes.
So there were only 30 boxes left in the storage room, although there were 64 boxes that were at Mar-a-Lago, to your knowledge, based upon this indictment.
Well, they returned 30. How many more were still in there that they hadn't taken at all? That would be added to that.
Why was there any significance to moving all these boxes prior to June 2nd of 2022? And I believe this is referenced in the false certification of the FBI section of the indictment. But what's the significance of moving all these boxes just before June 2nd of 2022?
Because Donald Trump was on notice that his attorney was going to search that room, search for classified documents in that room, and in between the time he was put on notice of that and the time that he actually did that, at Donald Trump's direction, 64 boxes were taken out, but only 30 were returned.
So how many boxes did Mr. Trump's attorney actually review when he returned to Mar-a-Lago for the review on June 2nd of 2022?
The attorney looked through all the boxes that were in the room and located, reviewed the contents of the boxes in the storage room, and he located 38 documents with classification markings that he took out and he put in a red roll folder, and that he then taped up.
Let's move on to the next section about the attempt to delete security camera footage. And we're working our way up to this August court-authorized search of Mar-a-Lago, if you can't see where we're going here. So on page 27, that's the section that starts the attempt to delete security camera footage. Did the evidence show that Mr. Trump attempted to or tried to direct someone else to delete security camera footage at Mar-a-Lago?
Yes.
Can you please describe from the indictment, of course, what evidence showed that Mr. Trump directed someone to delete security footage at Mar-a-Lago?
There was a draft grand jury subpoena for the production of security camera footage, and the previous paragraph notes that agents had observed surveillance cameras near the storage room where the classified documents were stored.
It looks like Mr. Trump had a phone call with Mr. De Oliveira the day after, on June 23rd of 2022. Is that correct?
For 24 minutes.
Yes. And then the actual subpoena was sent by the Department of Justice to an attorney from Mr. Trump's organization on what day? And I believe it's in paragraph 77.
Yeah, Friday, June 24th.
And what was that subpoena? What records was it requesting?
Any and all surveillance records, videos, images, photographs, and/or CCTV from internal cameras at certain locations at the Mar-a-Lago Club, including on ground floor basement, from January 10th to June 24th of 2022.
Notably, the same day that the Department of Justice emailed Mr. Trump's attorney the actual final grand jury subpoena, it looks like Mr. Trump may have tried to reach out to Mr. Nauta, and it's described in paragraph 78. Do you mind?
An attorney for Trump speaking to Donald Trump about the subpoena for security footage. A little over 2 hours later, Waltine Nauta received a message from a coworker indicating that Trump wanted to see him. And then less than 2 hours after that, Nauta, who was supposed to be traveling with Trump to Illinois that day, changed his plans to travel and began making arrangements to travel to Palm Beach instead of Illinois, where he was scheduled to be with Trump.
To a Trump employee, what position did the Trump employee have that Mr. Nauta, Mr. De Oliveira reached out to? This is in paragraph 80.
Let's see. He was the Director of Information Technology.
And
Paragraph 80 reflects a series of contacts and conversations. First, Nauta reaching out to the Director of IT, asking if he's around. Nauta then also reaching out to De Oliveira, and then it appears they had a call after he reached out. The last entry is Trump, that same employee, the Director of Information Technology, texted now to say, if you need me, I can get away, just let me know. Now to responded saying, sounds good, thank you.
Conversations, it looks like Mr. Nauta and Mr. De Oliveira actually go and look at some of the information technology at Mar-a-Lago Social Club. Can you tell us what Mr. Nauta and Mr. De Oliveira, who did they go visit? I think they went to a security guard booth, is that correct?
Yes, there's a security guard booth where at that booth, it has where the cameras are, so you can see where the surveillance cameras, like that would be where you could see them. And then they walked with a flashlight through the tunnels where the storage room was located and observed and pointed at the surveillance cameras that were there. De Oliveira walked to the IT office where this same director of IT was working with another employee. There were two people there, and requested that the director of IT step away so he could talk with him. They left the area and they walked through a basement tunnel to a small room that was known as an audio closet. And once inside that closet, he being De Oliveira, told the employee first that their conversation should remain between them. He then asked how many days the server footage was retained, and the employee told him approximately 45 days. And then De Oliveira told the employee that the boss wanted the server deleted. The employee responded that he would not know how to do that, and he did not believe he would have the rights to do that. Trump employee, that same employee told De Oliveira that De Oliveira would have to reach out to another employee who was a supervisor of security for Trump's business organization. But De Oliveira persisted and insisted that insisted to Trump employee that the boss wanted the server deleted and asked, what are we going to do?
Did the evidence show that Mr. Trump had any conversations with Mr. De Oliveira? And I'm referencing paragraph 87.
Yes, on 3:55 p.m., they spoke for about 3.5 minutes.
So we're on June 27th of 2022, and then we move to July of 2022. Did the FBI and grand jury actually obtain any of the surveillance that they requested through their grand jury subpoena?
They did.
And then following the FBI and grand jury obtaining the surveillance video, can you explain what happened?
Sure. The FBI executed a search warrant at Mar-a-Lago. The search warrant was authorized the FBI to search and seize, among other things, all classified documents. There's one thing I just want to correct, though.
Yeah.
The chronology we've gone through, all of those facts were not known to the FBI at the search warrant. Many of them were, but for example, this last bit where we talked about attempting to delete the server, that was not uncovered until later.
Thank you. And during the execution of this court-authorized search of Mar-a-Lago Club in Florida, did the FBI actually seize any documents with classified markings, classification markings?
Yes.
And approximately how many documents did they seize with classification markings?
It's that they seized 102 documents with classification markings, and there's a chart that lists the level of classification and where they were found.
And just a note for the record, some of the classification markings that were found included top secret classification markings, secret and confidential, and as you just said, for a total of 102 documents.
Yes, and if I could, I want to correct something I said before. I stated what it means if a document's top secret, and I said it is grave damage to the national security. Actually, a top secret document, and I'm looking at paragraph 14A, is information that reasonably could be expected to cause exceptionally grave damage to the national security. Secret is grave damage to the serious damage to the national security.
In addition to just the members and the staff that were there, what types of events might have been held at Mar-a-Lago where these classified documents were found during your court-authorized search in August of 2022? And this is referencing paragraph 12.
So paragraph 12 states that In the period between January 2021 and August of 2022, the club hosted more than 150 social events, including weddings, movie premieres, fundraisers, and those events together drew tens of thousands of guests.
Exhibit 13 will be a House Judiciary GOP tweet that says, "This is what happens in third world countries, not the United States. Doesn't the FBI have better things to do than harass the former president?" And this tweet is from August 8th of 2022. And then exhibit 15 will be an August 8th, 2022 tweet from Speaker Kevin McCarthy that says, "Attorney General Garland, preserve your documents and clear your calendar." What is your response to statements, and actually I want to preface this by saying, look, I understand that you were not the special counsel when this search was conducted in August of 2022, but what is your response to statements made accusing the FBI of harassing Mr. Trump in the aftermath or after the FBI conducted its court-authorized search of Mar-a-Lago?
I don't think those statements are accurate.
Do you, can you explain why you do not believe they're accurate?
The search of the Mar-a-Lago Social Club was conducted pursuant to a warrant, a search warrant, as the Department of Justice and FBI does every day, continues to do every day. It was approved by a United States magistrate, and
In your prosecutorial experience, can you describe what types of factors a prosecutor would have considered before seeking a court order to search someone's home or private residence?
well, most clearly, you would need to have a factual support for that basis, and a reason to believe that evidence of a crime would be recovered, and probable cause to believe it would be recovered at the location you're asking to search, based on the facts. It was before I was special counsel, but yes, they presented an affidavit to a court, and that court approved a search warrant.
Okay, thanks. And even earlier than that, I mean, would you say that President Trump had multiple opportunities to return the classified documents that he had retained back to the federal government voluntarily?
Yes.
He had an opportunity to return them when the National Archives first asked for them back, right?
Yes.
And then he also had another opportunity to return them when he was subpoenaed by the grand jury, right?
Correct.
And he did not return all the documents during that time, right?
That's correct.
And based on your indictment, is there information that led you to believe that he was aware that at least some of these documents are highly sensitive documents?
Yes.
Can you draw any conclusions about his refusal to return those documents in spite of having been given multiple opportunities?
I don't think I can answer that question because it may involve non-public facts that are part of the final report that is currently under an injunction.
Just one last question. Did you come across in the course of your investigation any evidence about why President Trump took those documents in the first place?
Again, I don't think that's in the indictment here, and unless you have a public filing, that given the current state of the injunction, I don't think that's a question I can answer. References on July 21st of 2021, Trump gave an interview, and this was when he was no longer president, at Bedminster. Two members of his staff were there, and the interview was audio recorded with his knowledge and consent. Before the interview, media had published reports that at the end of Trump's term as president, a senior military official purportedly feared that Trump might order an attack on country A, and the senior military official advised Trump against doing so. Paragraph 35 says, upon greeting the writer and publisher and his staff members, Trump stated, quote, "Look what I found. This was senior military official's plan of attack. Read it and just show it's interesting." And then following that, there are additional statements that Donald Trump made regarding the document that he was showing and what other people in the room said. Staff members referred to these documents as the, quote, beautiful mind boxes, meaning they were, and this wasn't just one staff member, it was multiple staff members, and they referred to the fact that Donald Trump, these were his boxes, they were exclusively his belongings in them, he had curated them and what was in them, and so his position was, all of this is mine. Well, if his defense were that he was intending to take classified documents that he had no authority to take, and he did it intentionally because he wanted to start a presidential library and keep those documents in the locations that we talked about today, that's a crime. The Secret Service provided protection services to Trump and his family after he left office, including at Mar-a-Lago, but it was not responsible for the protection of boxes or their contents, and the indictment states that Trump did not inform the Secret Service he was storing boxes of classified documents at Mar-a-Lago, meaning they didn't know that they were protecting classified documents. I think in our conducting both of these investigations, we did it consistent with the best traditions of the department and the principles that Justice Jackson was talking about there. So yes, I do think in both cases, we adhered to those principles.
And is it also fair to say that you were, in fact, trying to get these cases wrapped up before the election in 2024?
We were trying to move these cases expeditiously. In our briefs, we cited to repeated Supreme Court precedent that states that the interest in a speedy trial, the right to a speedy trial, isn't just the defendant's right, it's the public's right as well. And given the gravity of these crimes and the public interest, it was our duty to move them forward as expeditiously as we thought fair and reasonable.
You know, in terms of administering elections. And the Supreme Court changed that and said that, you know, signature verification wasn't required. You know, the volume of absentee ballots was completely different than an ordinary election. There were over 2 million, you know, absentee ballots. And so, you know, we just wanted to point out, and I guess ask you the question, were you aware of all these irregularities and disparities because of the, you know, because of the COVID and so forth? So many things had changed by the time it got to Election Day in Pennsylvania.
Well, what I can say is that some of the issues you raised are the sort of issues that a campaign or someone who's a candidate can raise in the courts, and I believe a lot of these issues were raised in the courts. I think Donald Trump lost those litigations, and as we pointed out in our indictment, that bringing a lawsuit for some of the issues you talked about, that's the proper way to dispute these things, or asking for a recount, as President Trump did in 2 states. Our case was about false allegations of fraud. Our case, we did the things you just mentioned, we didn't allege those to be part of the fraudulent conduct targeting a government function. And so again, those are issues that I think we were aware of in studying these things and in speaking to election officials there. But they're the sort of issues that are dealt with through litigation in our court system, and I think that's what happened in the election after.
So, Mr. Smith, you spoke earlier today about threats and attacks against, made by Donald Trump against witnesses, prosecutors, judges who had challenged him, including threats against yourself. Do you remember that?
Yes.
So, did President Trump target you personally in posts on Truth Social?
Yes.
Are you aware, for example, that he called you a, quote, deranged lunatic, unquote, quote, Trump hater, unquote, and, quote, psycho?
Yes.
Do you recall that on October 15th this year, President Trump, speaking to reporters standing next to the Attorney General and the Deputy Attorney General, said, quote, deranged Jack Smith, in my opinion, is a criminal, unquote. Then he also talked about investigating Lisa Monaco, Andrew Weissman, and Adam Schiff. saying, quote, "I hope they're looking at all these people and I'm allowed to find out. I'm in theory the chief law enforcement officer," unquote.
Yes, I'm aware of that.
And are you aware that President Trump posted on Truth Social on October 29th of this year that, quote, "These thugs should all be investigated and put in prison. A disgrace to humanity. Deranged Jack Smith is a criminal," with 3 exclamation marks, unquote.
That may be, I know there were several posts like this.
Okay. Do you think those were a potential direction to the Department of Justice to retaliate against you because of your role as special counsel in the investigation of him?
Yes,
You are joined by your counsel today from Covington and Burling, is that right?
yes.
And did President Trump or the White House take any actions against your attorneys due to their relationship with you?
Yes.
And what action did they take?
They filed an executive order against the law firm and sought to withdraw the security clearances of my attorney.
That this executive order says, "I hereby direct the Attorney General and all other relevant heads of executive departments and agencies to immediately take steps consistent with applicable law to suspend any active security clearances held by Peter Koski and all members, partners, and employees of Covington and Burling LLP who assisted former special counsel Jack Smith during his time as special counsel, pending a review and determination of their roles and responsibilities, if any, in the weaponization of the judicial process." And the executive order also directs the Attorney General and heads of agencies to take such action as are necessary to terminate any engagement of Covington and Burling LLP by any agency to the maximum extent permitted by law and consistent with the memorandum that shall be issued by the Director of the Office of Management and Budget. Did I read that correctly?
Yes.
To your knowledge, is this executive order still in effect?
I believe it is.
What do you think was his purpose for issuing this executive order?
To seek retribution against me.
Is it also to harm your relationship with your attorney and to make it more difficult for a lawyer to represent you?
I think it's to chill people from having an association with me.
I just want to say for the record, we're still here, proud to represent Jack Smith.
Thank you. So once President Trump took office, were members of the special counsel's office, was their employment affected?
Yes,
Were they fired?
yes.
Do you know roughly how many people were fired?
I don't have specific numbers.
Is it more than a dozen?
I believe so, yes.
Okay. Do you know who fired the former members of the special counsel's office?
I'm assuming the president did. I don't know the specifics, but
Okay. Do you know how the termination messages were communicated?
I don't recall if how they were communicated.
And these are career attorneys and agents, is that right?
That's correct.
Okay. They're not political appointees. They've served different administrations with different political parties at the head. Is that right?
That's correct.
Do you know what justifications were given for terminating those staff members?
My understanding is no justification was given.
Are you aware of any reason to target these individuals besides their work on your investigation or association with your investigation?
None. I think it's a travesty.
Do you believe, well, you just answered it, but do you believe it's proper to retaliate against career prosecutors for their involvement in a federal investigation?
Of course not.
What about the support staff who aided those prosecutors?
I don't understand that, why you would do that.
And what about FBI agents who carried out this investigation?
As I said earlier, I don't understand why someone would seek to do that.
Do you think that firing all of these public servants make the country safer?
No.
Why not?
As I mentioned previously, I think when you fire people who are career public servants, serving both parties over many decades, you lose the expertise about how to do the job properly, and that has an effect on the department today, and it'll have an effect on the department for some time if those people aren't there to be leaders and to teach young lawyers how to be public servants.
Do you feel like you have a target on your back?
I believe that President Trump wants to seek retribution against me because of my role as special counsel.
Would you be surprised if President Trump directed the DOJ to indict you?
No.
Are you concerned about the safety of people who associate with you, like your former colleagues and your attorneys here today?
I would prefer, if it's all right, not to talk about my safety because I think doing so could in fact endanger my safety and those of people around me.
Understood.
I'm going to turn a little bit to the folks who actually attacked the Capitol on January 6th. I believe your report talks about the rioters, the crowd that violently attacked the law enforcement officers attempting to secure the building on page 25 of your report. One of those rioters was Daniel Rodriguez, who multiple times plunged a stun gun into the neck of Officer Michael Fanone, causing Officer Fanone to suffer a heart attack and sustain other injuries. Mr. Rodriguez was subsequently sentenced to 12 years in prison after a federal judge called him a, quote, one-man army of hate. Are you aware of President Trump pardoning Mr. Daniel Rodriguez?
Not him specifically, but my understanding is he pardoned all the people who violently assaulted police officers that day.
So in pardoning all the people who assaulted police officers that day, another example is a Mr. Patrick McCaughey III, who used a stolen police riot shield to crush Officer Daniel Hodges in a metal door frame at the entrance of the Lower West Terrace Tunnel, and he left Officer Hodges trapped, bleeding, even crying for help from his fellow officers. Officer Hodges testified, and this is a quote, if I was there much longer being assaulted in such a way, I knew that there was very likely I wouldn't be able to maintain my consciousness. Judge Trevor McFadden described Mr. McCaughey as a, quote, poster child of all that was dangerous and appalling about January 6th, stating that his actions were, quote, some of the most egregious crimes ever committed that day, end quote. Mr. McCaughey was sentenced to more than 7 years in prison. Are you aware that Mr. McCaughey was one of those rioters who assaulted law enforcement on January 6th that were pardoned by President Donald Trump?
Again, I don't know his specific name, but I know people like him who did things like he did were pardoned.
And are you aware of the more than 140 police officers who were injured by the pro-Trump mob on January 6th, sustaining injuries such as cracked ribs, traumatic brain injuries, smashed spinal discs, and heart attacks as rioters used bats, flagpoles, chemical sprays, stolen police shields, and batons to beat officers? Are you aware of those facts from that day?
Very much so.
Do you believe that pardoning individuals like this who committed crimes against law enforcement that day makes our country safer?
It does not, in my view.
Can you explain why, from your prosecutorial experience, prosecuting gangs, prosecuting violent crimes, why pardoning individuals who committed violence on January 6th doesn't make our country safer?
Well, I don't think it's really my opinion. I think we've already seen some of the people who were pardoned go on to commit other serious crimes, and I don't have much doubt that in the coming months and years we'll see more of that. People who would otherwise be incarcerated, communities protected from them, they're out in communities, and my view is that we will continue, unfortunately, to see people who were pardoned for committing violence on January 6th continuing to commit additional crimes. That's my view.
Some of these individuals that were pardoned include Mr. Giuliani, who we talked about earlier today, who was willing to spread knowingly false claims and work to subvert the results of the 2020 election. Are you aware of that?
Yes.
I guess taking a step back and looking at the fact that President Trump pardoned these folks, these 77 individuals who were previously working to overturn the election, the 2020 election, what message does that send to folks living in the country, particularly as it relates to election integrity in future elections?
You know, I just, I don't understand why you would pardon people who assaulted law enforcement. I think it sends lots of messages. One of the messages is to law enforcement, the people who defended the Capitol that day, in my view, are heroes. And I think pardoning people who assaulted them is wrong.
And what about pardoning the folks who actually worked on the conspiracy to overturn the election? What message does that send about election integrity to folks living in the country?
Well, I don't have a full list of all the people that he pardoned there, and so I don't want to speak generally about all those cases. We didn't charge anybody other than Donald Trump, and so I'm not going to speak about pardoning people who weren't charged with crimes.
All right, we'll go off the record.